Welcome, everyone, to another deep dive. Okay, let's think about this for a second. You've put in all the work, got that dream job in the US, navigated the whole visa maze. You're finally here, things feel, stable, but then maybe there's a small change at work, something that seems minor, or maybe you just didn't quite catch a specific rule. Suddenly, your whole legal status could be, well, on shaky ground. And that's kind of the core of what a recent warning from U.S. Citizenship and Immigration Services, USCIS, is highlighting for anyone holding an employment visa. It's not just about the basics anymore. It's really about understanding these shifts in how rules are enforced and what small actions might actually mean. So, our mission today, let's unpack this USCIS alert. What's it really saying to you, whether you've got an employment visa now or you're thinking about getting one? And probably the biggest question, how can you stay informed and, crucially, compliant?
Yeah, it's such a critical conversation to have right now. What's fascinating here, I think, isn't just that these laws exist, they always have, but it's the intensified focus USCIS seems to be putting on compliance now. Navigating immigration, it's definitely not a set it and forget it deal.
Yeah.
It really needs constant attention, vigilance, and a real grasp of what's changing because, like you said, one seemingly small misstep, it can spiral into pretty significant life-changing consequences. This warning feels like a signal of that.
Absolutely. And that signal leads us right into the main topic. This very direct, pretty stern warning from USCIS. And this wasn't some quiet update buried on a website, right? This was a public alert aimed right at foreign nationals here on employment visas. The message was crystal clear. Fail to show up at your designated employer or leave that job but don't properly leave the country, you're breaking U.S. immigration law. And they were blunt about it, saying you will face legal consequences. No ambiguity there.
That's right. And it's so important to see this not just as a general reminder of old rules. This feels like a specific tightening of enforcement, a more proactive stance. They even put it out there on their official X page, what used to be Twitter. And the language was stark. They used the official term aliens, stating quite plainly, aliens who enter the U.S. on an employment visa but fail to report to their designated employer or leave the job without returning to their home country are in violation of immigration laws and will face legal consequences.
Wow.
Yeah, and if you connect that to the bigger picture, well, this kind of public messaging from a federal agency really hammers home that compliance isn't just a bureaucratic detail. It's literally the foundation of your legal right to be in the country. It signals they're serious about accountability, maybe even taking a harder line on things that might have seemed like smaller issues before.
Right, not just theory. And they backed it up, didn't they? This alert came out right after a real-world enforcement action, which kind of serves as a case study. They highlighted a situation involving a worker on an H-2A visa. Now, for listeners who might not know, that's the visa specifically for temporary agricultural work. This person was supposed to report for duty in Florida under the terms of their visa, but they didn't. And here's where it gets, well, pretty sobering, as you said.
Yeah.
This worker wasn't found in Florida. Authorities located him way over in Fresno, California, and from there, referred directly to ICE Immigration and Customs Enforcement. USCIS pointed to this case specifically to show the serious outcomes, like potential deportation. It shows they mean business.
Exactly. And that H-2A case is worth looking at a bit closer, because even though it's one specific visa type, the principle behind the enforcement applies much more broadly. So the H-2A program itself allows U.S. employers, mainly farms, to bring in foreign workers for seasonal jobs when they can prove they can't find enough U.S. workers. There are rules about protecting U.S. workers' wages, and the visa is usually granted for up to a year, renewable but capped at 3 years before you have to leave for a bit.
Okay.
But the key takeaway from this example isn't just about H-2A rules. It's that non-compliance, like just not showing up for the job you were approved for, can immediately trigger action from ICE, finding him across the country and referring him for potential deportation. That's serious. It raises that big question. What does this level of enforcement mean for everyone on an employment-based visa, not just H-2A?
That's exactly the crucial point. Because while the H-2A story is a very clear, maybe even stark example of enforcement, this USCIS warning wasn't just about H-2A. It really applies across the board. So whether you're here on an H-1B, an L-1, O-1, any of these employment-based visas, the fundamental message is the same. Your legal status, your ability to stay here, it completely depends on you strictly following the employment conditions tied to your specific visa.
Precisely. And the responsibility for that falls squarely on you, the visa holder.
Yeah.
It's about making sure your actions line up with what your visa allows. And, people might not always realize what counts as a violation. Think about H-1B holders, maybe during layoffs. There's that 60-day grace period people talk about.
Right.
And it exists, yes. But with this enforcement climate, any misstep during that time, maybe working a few hours somewhere you shouldn't, or even just misunderstanding the rules about travel during that period, that could become an issue.
I see. So even things during that grace period need careful handling.
Absolutely. USCIS looks at the whole picture. What if your job changes significantly? Your visa was approved for this role, but now you're doing something quite different. That might need an amendment. Or think about remote work, which is so common now. If your company lets you work from a different state than the one listed on your labor condition application, your LCA, well, that needs to be looked at carefully too.
Okay, that makes sense. These aren't just minor details then.
Not at all. If they're mishandled, they can quickly put your status at risk, potentially leading to serious legal trouble like removal proceedings. And that can affect everything down the line. Future visas, green card applications, everything. It demands active, proactive attention.
That really underscores how widespread the implications are, touching on situations that probably seem pretty normal in today's workplaces. So, okay, given how serious this is and the potential fallout, it's clear being proactive isn't just a good idea, it's vital. What can you, the listener, the visa holder, actually do to make sure you're compliant and avoid these kinds of problems?
You're absolutely right. Proactive steps are key. We can break it down into, say, 3 core actions, plus maybe an overall mindset. And this applies to dependents too, by the way. First, and this is non-negotiable really, consult with an immigration attorney. Seriously, do this before you make any big changes. Thinking about a new job, employer merging, need to relocate, even for remote work, talk to a lawyer first. Don't wait for a problem.
Okay, so get legal advice up front.
Yes. These things are complex. Get expert advice tailored to your visa, your situation. It's not optional if you want to be safe. Second key thing, formal and timely communication. If your job ends layoff, you resign. Whatever the reason, you need clear, documented communication with your employer and with USCIS.
How formal are we talking?
Think documented. Formal letters, maybe certified mail, keep copies of emails. Understand how your employer notifies USCIS about termination. Does your employer formally withdraw the petition? Knowing that can be important. No room for doubt about your status.
Got it. Clear paper trail.
Exactly. And third, underpinning everything. Rigorously comply with all the terms of your specific visa. This isn't just about having the job. It means understanding the details in your petition, your LCA if you have one, the job title, the wage, the work location. Significant changes often need official updates, like an amended petition. Don't work unauthorized hours. Don't work for someone else on the side if your visa doesn't allow it. Stick strictly to what your visa permits. That's your best defense against deportation risk or future visa problems.
Okay, attorney first. Communicate clearly. Stick to the rules strictly.
Right. And maybe the overarching point is continuous vigilance. Immigration rules change. Enforcement priorities shift. You need to stay informed. Follow reliable immigration news. Listen to discussions like this one. It's an ongoing responsibility to stay aware and proactive. These steps empower you to make informed choices to protect your status here.
This has been incredibly helpful, really digging into something so fundamental for so many people working in the U.S. So just to give a short brief of what we covered, USCIS has issued clear warnings indicating stricter enforcement of employment visa rules. We saw through the H-2A example that not sticking to your visa terms, like reporting to your designated job, can lead to serious consequences, including potential deportation. And remember, this applies to all employment visas, H-1B, L-1, others. Your legal status depends directly on following those employment conditions to the letter. The main takeaway here really is that understanding and meticulously following your visa's terms is absolutely critical for staying legal in the U.S. Being proactive, talking to lawyers before changes, communicating formally if employment ends, and rigorously sticking to the rules, that's your best strategy.
Absolutely. And perhaps a final thought to leave you with, just the sheer importance of staying vigilant and taking personal responsibility. Immigration law is complex, it's always changing, and keeping yourself informed is really key to navigating it successfully and securing your future.
All the best, and we will meet again with another important matter again.